We drum in that messaging around the dangers of COVID pretty diligently for a full 2-week period of sustained propaganda.
And on the 29th of June, Judge Harrison dismissed the applicant's appeal. Page 10 of the submissions goes on to the relevant statutory provisions. I believe sections 18, 7, 8 have all been discussed at length, and the key to this court is section 21C. We keep coming back to that. We then get to challenges to factual findings. At page 14. Sorry, page 13, relevant legal principles. Commerce Commission and Frontier Cooperative Group Limited held, and it goes back to the meaning of an enactment must be ascertained from its text and in light of its purpose. Your Honour, we've already discussed the text itself on the strict wording of section 21C, and we've also discussed the light of its purpose, which is the same purpose as the Fair Trading Act, according to Justice Elias in McBride Streetcars, to protect consumers and facilitate business, but not protect careless consumers. In TV NZ viewers, the Court of Appeal cautioned that the statute cannot be interpreted to permit unreasonable applications. In this case, again, it comes back to the elasticity of the wording. Parliament were elected and they didn't put minor in front of the word damage in section 21C. There's also reference to one of your Honour's cases, Rangitonga and Parker, where at 44, the alternate approach advanced by the appellant would not appear to be consistent with policy goals of the legislation and likely to lead to undesirable outcomes. And again, we're trying, when the CGA was implemented, we were harmonising laws with the CER. There's many acts in Australia that are identical here. The Consumer Credit Contracts and Finance Act is identical to the UCCCFA in Australia, as is this provision in the CGA. Also in Rangitonga, the approach advanced by the appellant could involve the unattractive prospect that offending which is merely incidental to the charge upon which the defendant is acquitted could not later be the subject of prosecution. Again, that would be an unwanted policy or purpose. Right. Interpretation should support a common sense and practical approach to the section, and certainty is a paramount consideration in commercial cases. Now, here we've been referred to Contract Pacific Limited and Commissioner of Inland Revenue at paragraph 30. On the clear wording of the section, we can see no escape from the conclusions, are the key words there. And at Partono against Ministry of Primary Industries, involving a crew of 3 foreign fishing vessels in New Zealand, unpaid wages of crew members. Interpretation is a paramount consideration in commercial cases. However, adherence to interpretive certainty does not justify the court taking a rigid approach when justice cries out to recognise the plight of the crew members. This is especially so where the reasons for the plight are weighty and not of their own making. Indeed, quite the opposite. This situation is not because of Mr. Murphy's own making. Mr. Murphy and Joden Finance didn't crash that vehicle. Joden Finance didn't cause the damage. Parliament would expressly say so if it intended it to set up 2 materially different consequences in a statutory provision. A statute should be interpreted in a realistic and practical way in order to make it work. Strained interpretation should be avoided. And here we come back to the elasticity of Section 21C. And there's 2 parts to this section: damage, and then how did that damage arise? And that's where the judicial discretion comes in. How did the damage arise? It wasn't related to Joden. And that's the simple, certain and clear interpretation. There is no justification for dissonance. In Manukau City against Ports of Auckland, at 13, and I think that's in our casebook here, Lord Cook said, had that been the intention of Parliament, it would have said so in unequivocal terms. And
I'm reasonably familiar with the legal principles, so perhaps, given you've got about 15 minutes left, it perhaps might be good to move on to about 16 and tackle the substantive submissions.
Right, substantive submissions are on the right code, really.
Paragraph 31.
Paragraph 31. Oh, yes, I
I mean, to some extent, I think you've already covered part of this in dealing with the legal principles on it.
Yes. First ground, error of law, interpretation of Section 21C of the Act. Your Honour has absolutely correctly identified that we keep coming back to this and running it home. That once damage is a material fact admitted in the tribunal, throughout it, everyone knows who did the damage. The only judicial question after that was, did the original commission of the car cause that damage? And it didn't. And there's a host of Australian cases we've included in there which show how the Australians come to that. There was Dante the stallion that was gelded, not properly, as it turned out, and caused havoc. That was the Australian jurors took that back and tied it to the original damage. The horse was always damaged. There's also LS&H holdings in these submissions. Again, all these cases have been interpreted correctly on the exact same section as we have. The plain wording of the section is only qualified by 2 parameters: whether the goods were damaged after delivery to the consumer and that the damage was not related to the condition of the goods at the time of supply. It follows that damage arising after delivery to the consumer that arises because of the stable condition of the vehicle at the time of supply does not result in loss of the right to rejection under Section 21C. It also follows that if the damage arising after delivery has no nexus to the stable condition of the goods at the time of supply, the right of rejection is lost. And that word nexus, that's the key for the Australians, and it's the key for us. Of particular significance is that Parliament has not expressly said that there is an additional qualifier to Section 20 pertaining to an evaluation of the extent of damage to the goods in circumstances where it is established on the evidence that the damage is caused after supply. There is no evidence that the damage is caused on the supply. It is submitted that such an omission is intentional. That is because attempting to define and quantify a damage threshold on a product-by-product, case-by-case basis would not be workable, and it would not cause harmonisation across the Tasman. Each good would require a fact-specific assessment of damage supported by an objective evidence-based quantified evaluation of loss of value to the good or the cost of repair, measured against an unknown threshold of what was significantly enough damage to engage this way would be contrary to the principle that there would be certainty in the law, particularly in the commercial context. If we're going to quantify damage, then the court needs to appraise itself or make inquiry as to that damage. Before it can say it's minor damage, there was no inquiry. Evaluating the section in light of the broader purpose of the Act, Section 1A recognises the need to protect consumers as well as the need of business to compete effectively, and the need for consumers and businesses to participate confidently. Section 1A2 of the Act provides consumers have guarantees that goods are reasonably safe for the purpose and are of acceptable quality, while Section 1A3 provides that consumers have a right of redress when suppliers fail to comply with those guarantees. Losing the right to reject goods under Section 21C in circumstances where the damage is caused after delivery to the consumer not related to a stable condition at the time of supply does not undermine the Act's purpose. That is because the purpose of consumer protection and a remedy when a breach of consumer guarantee under the Act is found is not lost by interpreting Section 21C in this way. It is only the right to reject that is lost. The consumer still has other remedies available. Now, we've referred the court to prior district court judgments that have come down and used what is defined as the harsh approach. But we would submit those are the correct approach, as in Wright and Fortis Panmure Limited, Mitchell and Trading Post Limited, Poe and Harvey, and they're referred to at page 40 of the submissions, and footnotes 57, 59. Mitchell and Trading Post. Now, Mitchell and Trading Post is interesting. Mitchell and Trading Post involved scratched the front bumper. Minor. But again, it was harsh. The approach doctrine was harsh, at some point in time, the NBDT has changed and started making law that they weren't elected to. Now, no, we're looking for Richmond Trading. I think the best description of jurors on this particular section is discussed in LSH, Auto, Sydney and Sherman, where there is a reasonably in-depth analysis on why Section 2621C of the Australian Act provides a statute bar for the right of protection in the same way as Section 21C, and the available avenues for judicial decision makers. And again, we've included Barton and Bridgman, where the court presented that if Section 2621C of the Australian Act was read down in a way that resulted in the loss of the right to protection, whatever the damage, that did not leave the consumer without a remedy again. The Australians are saying the same as they are here. There's still other remedies out there. Other Australian authorities we've included are Pate and Niche Holdings, Ross and Hereford. Further New Zealand authorities do not really assist at present because those cases deal with a fluxion of time. They're all temporal based. As, interestingly, were the Saskatchewan cases that we looked at. So the thrust of the above is just to emphasise that the only wiggle room to allow rejection of damage under Section 21C is to tie damage caused after supply with damage arising from damage that existed at the time of supply. Otherwise, damage caused after supply, not related to a stable condition at the time of supply, will result in the loss of right of rejection. We'd also question Harrison's definition of damage. His Honour flipped to the Oxford Dictionary and chose one of 7 different available definitions, which damage could be any one of those definitions, not just the particular one that he liked on the day. Damage can mean any harm whatsoever. Section 50 of the submission, it is submitted that the interpretation we offered today is clear, certain, workable and fair when considered in light of the Act's purpose. And that the interpretation given by His Honour Harrison DCJ was an error of law and should be quashed. Getting on to the second error of fact, failing to consider facts, misrepresentation of facts. The argument is fourfold. Harrison erred in upholding the NBT decision that the damage caused to the vehicle's wheel was minor. It wasn't minor. 2, that the damage to the vehicle was in fact more significant than to the vehicle's wheel. We've established that with the photos today. 3, that Harrison DCJ erred by failing to take into consideration the more significant damage, which we've highlighted today. And 4, that Mr. Cressler misrepresented, withheld material facts from the NBDT and Harrison DCJ and impugning those decisions. Relevant to this ground is the function of an appeal under Clause 16 of Schedule 1 of the Motor Vehicle Sales Act 2003, which provides for appeals where the claim exceeds $12,500. The appeal may be brought against the NBDT's decision on the basis that the decision was wrong in fact or more. The applicant's appeal was brought on both grounds, and I understand that is something that Your Honour will determine. The notice of appeal inserted an error of law for being ultra vires, Section 21C, and that damage, a question of fact, invalidated the right of restriction. The applicant says further that Harrison and DCJ dismissed the application on the basis of a misapprehension of a comment made by its director, Mr. Murphy. The applicant asserts that at all material times he intended to be progressed on both questions of law and questions of fact. The applicant further says the question of law raised was contingent on factual determinations in the dispute. And that's what I said at the outset of my submissions. Error of law can involve error of fact. Next we go on to minor damage of the wheel. The MBGT found that the damage to the wheel was minor and consistent with ordinary wear and tear, such that the right of rejection was not lost. And we look at Mr. Preslip's evidence on this point. It was too dark, so I hit the footpath, the wheel, the car got flat tyre. I mean, the wheel hit and the car got flat at the same time, so I will get the spare wheel. And then earlier on, Mr. Preslip, we'd already discussed this, was he refers to sometimes when we don't know how many times he's hit the curb in this vehicle. Sometime could be more, or it could, how many times? It's a question mark. From Mr. Preslip's evidence, it can be inferred that the impact to the curb was significant by virtue of the evidence. The impact immediately burst the tyre, causing it to go flat. Furthermore, the damage to the wheel was not on facts wear and tear, rather it was damage caused to the vehicle by Mr. Preslip's careless driving. It was a minor motor vehicle accident, but the damage was not minor. Nor is there any ability for the MBDT to invoke the word minor. The MBT was wronged to rely exclusively on the photographs provided by Mr. Preslip to assess the extent of the damage. It could and should have exercised its powers under Clause 9C3 of Schedule 1, as it has in other cases, and made its own investigations. I understand that the practice used to be that the MBD inspector would actually just go downstairs and have a look at the vehicle during the hearing if needed. That could have been done in this instance if the MBDT was going to make an assessment of damage. The MBT insisted Joden paid for the car before it brought it back to inspect that damage. It just seems a little bit illogical. So the evidence before this court is that the damage caused to the wheel, which can be repaired, and tyre, which needs replacing, totals 1,204, excluding GST. Significant damage to a vehicle with a purchase price of $14,995. It's submitted that Harrison DCJ was wrong to engage with this issue. It was material to a question of law being decided upon in circumstances where the question hinged on factual determinations that ought not to have been ignored. Both the MVDT and Harrison DCJ failed to take reasonable steps to inform themselves, which is a viewable error of law. Furthermore, the issue was material to the outcome of the appeal, such that the 30th of June decision ought to be quashed and remitted back to further determination in light of this court's judgment. Now we move on to the more significant damage and failures taken into consideration. This is why we have Joden has adduced fresh evidence that was disallowed. The fresh evidence before the court is summarised to include damage to a front left indicator lens, 2 rear brake lights, and the front and rear bumpers.
Okay, I've got that. That's 63.
Yeah, that's further up. So 4,300 excluding GST. And the thrust of the submission is that actually, well, the damages equate to about a third of the cost of that motor vehicle.
Okay, should we wrap up?
Yes, and lastly, misrepresentation of facts. It is submitted that a significant aspect of the proceeding that cannot be overlooked is that there is incontrovertible and unchallenged evidence before this court that Mr. Presslett misrepresented the extent of the damage to the vehicle to the MVDT. As the extent of the damage to the vehicle was central to the remedy that Mr. Presslett obtained, the misrepresentation also impugns upon the Auckland District Court decision that upheld the MVDT decision. The interests of justice require the intervention of this court to remedy that outcome. And lastly, unreasonableness. Basically, 68, Mr. Presslett's parking accident, or accidents, if we go back to the transcript, possibly accidents, is clearly inconsistent with ordinary wear and tear. The applicant submits the motor vehicle accidents very clearly fall out of normal range of use. Driving into a concrete object is not a normal use of a motor vehicle. Concluding to the contrary is not within the limits of reason. No reasonable body of persons could have arrived at the conclusion that damage caused by a motor vehicle accident is consistent with ordinary wear and tear. It follows that the MVTC's finding on this point was irrational, and by that implication of that, unreasonable. It is submitted that it also follows that Harrison DCJ's decision is unreasonable for upholding the proof from the poison free. Now I have paragraph 71, I take it you want to read that. And that would be my conclusion.
Great, thank you for that. Madam Registrar will take the agreement.
Well, I'd like to begin at paragraph 7 of Council's submission, where I will would like to address the court briefly regarding some principles of judicial review. The High Court has inherent powers of judicial review to supervise public decisions and ensure they are made according to law. Judicial review, however, is not an opportunity for disgruntled litigants to simply re-argue their case. Where a decision of an appellate court is being reviewed, the disputable issues will usually be very narrowly defined. It is inappropriate on the judicial review proceedings to allow plaintiffs to have a de novo hearing. Your Honour, the applicant please review on the basis of 3 grounds. The first is error of law. A wrong interpretation of the law which materially affects the decision can form the basis of a challenge for judicial review. If the decision is made on incorrect finding of the law, it is incumbent on the court to rectify that. However, judicial review for an error of law cannot be used to disturb the district court's factual findings. Now, I'd like to refer to the case of McBride Street Cars Limited in District Court at Dunedin. This is at tab 3 of the fundamental authorities filed by the second respondent. Probably the smallest of all the bundles on the page. All the bundles got 3 pages. 8, 9, and 10. Oh, right. My apologies. This one should have 9 tabs, and we're looking at the third one. McBride Street Cars is also a judicial review of a district court appeal of a motor vehicle dispute appeal decision. In this case, McBride Street has sought judicial review on the ground of error of law. In that case, the District Court on Appeal upheld the finding that the motor vehicle disputes tribunal that McBride breached Section 9 of the Fair Trading Act and engaged in misleading and deceptive conduct. If I can refer you to page 297, at paragraph 31 of the decision. And the court there says, the sole ground of review is that the District Court erred in law in finding there was a duty on McBride to dispose the statutory right of the vehicle. This is clearly a justiciable issue. If the decision was made on an incorrect finding of law, it is incumbent on this court to rectify that. However, some of the points relied upon by McBride in support of its argument are essentially challenging settled findings of fact, and it is not for this court on judicial review to allow such re-litigation, nor disturb the conclusions of the District Court on such facts. There may be exceptional circumstances where a clear mistake has been made, which requires a remedy, but no such mistake is here asserted by either party. So in this case, Your Honour, the court reviewed the facts upon which the decision was made, and these facts were not in dispute. And then it undertook a statutory interpretation exercise. The court looked at Section 9 of the Fair Trading Act, considered the case law, and it framed the legal question that was asked of the court on review. So turn to paragraph 59